Good evening, everyone, and welcome to this HJI Faculty Roundtable. This is our first program of the fall semester, fall 2024. We're pleased that you could join us. We have an exciting program tonight that I'm sure you'll find very informative. And we thank you for joining. We know that we have guests who have signed up from the New York area, from different parts of the US, and from around the world. So thank you, wherever you are, for taking time out of your busy schedules to be with us. My name is Stephen Boyd, and I'm the Dean of Enrollment Management and Student Life here at HJI. And during the program, in my role as Dean of Enrollment Management, I will share with you some links in the chat box that talk about HJI's programs of study. And if any of you are interested or have friends that might be interested in taking a class or applying to a degree program here, I'll put my contact information in the chat box, and you're welcome to copy that and contact me at any time. I'll be happy to help you. So once again, welcome. So first order of business is to introduce our host. Tonight, our host is Dr. Thomas Walsh, the president of HJI. He is the seventh president of our institution. We have benefited greatly from his leadership and experience, having come to us under True Mother's direction, having led for many, many years Universal Peace Federation as international chair, and also having had so much rich experience over the years directly with Reverend and Mrs. Moon, our co-founders of our institution. Dr. Walsh is a graduate from 1979, I believe. I'm doing this by memory.
That's
from
right.
HJI. And from here, he went on to complete his PhD at Vanderbilt University, highly prestigious institution. And since then, Dr. Walsh has been an editor, been a professor at various colleges and universities around the U.S. Now, currently, he is our president. And also, many students are fortunate enough to have him as their professor in recent semesters. This semester, he's teaching, among other things, the Unification Studies seminar that I'm sure many will benefit from. So we're so grateful that you take time out of your schedule to be with us here tonight, Dr. Walsh. So welcome. The floor is yours.
Thank you, Dean Stephen Boyd. Thank you for your great service to HJI. It's a pleasure to work together with you. Your role is extremely important in enrollment management, and you come with a blue ribbon background in that field of international enrollment management. So thank you for moderating tonight's program. This program tonight in our webinar series is devoted to Constitution Day. And Constitution Day was really enacted by a law of Congress in 1952 initially, and amended in 2004 and 5 to stipulate that institutions of higher education should honor Constitution Day annually on or around September 17th. And we have been, here at HJI, been honoring that tradition, not just because it was requested by an act of Congress, but because of a deep respect and love for the U.S. Constitution. And the topic we'll dive into tonight, which is the First Amendment. Our title of tonight's program is The First Amendment to the U.S. Constitution and its importance for religious freedom. At the same time, this program tonight is one in the series of our faculty roundtables, because our featured speaker tonight, Professor William Lay, is a member of our faculty, teaching particularly in our Peace Studies program. He teaches a course that is widely appreciated by our students in the area of human rights, law, and government. He has a background as a faculty member for many years at the University of Bridgeport, and he was the director of its program on international relations. So he is a perfect fit for tonight's program. He serves on the board of trustees here at HJI, and we benefit from his experience and background in many ways. He has a law degree from none other than Columbia University, practiced for years at a leading firm in New York City, and has often helped Family Federation in a number of ways on legal affairs. And he helped me over many years in my work in the area of nonprofits, particularly the Universal Peace Federation. So I'm grateful that he will speak to this important topic that's near and dear to Americans and to people of faith, particularly, and perhaps even more so to people of minority religions. So we're looking forward to hearing from Professor Lay, and without further ado, I invite you, Professor Lay, to deliver your presentation, and we'll have Q&A following.
Thank you very much, Dr. Walsh. It's my privilege to be delivering the Constitution Day remarks this year for HJI. I've done it many years. There's really nothing I like more than to discuss the Constitution, and I love to tell stories about it and talk about it. In fact, you'll see a challenge for me will be to sort of limit the length of my remarks and stay on the main topic here, which is the First Amendment. And in fact, the religious clauses within the First Amendment is really my focus. But I'll start out in a more general way. And let me go ahead and share my slides. And I want to make sure I do it right. Okay, good. I think you're seeing the single slide.
Looks very good.
And let me go with a little background here. You know, the day that we are honoring here, which is September 17th, was the day that the drafting of the Constitution was finished in 1787, and it was signed and it went out for ratification. And at that time, it did not contain a Bill of Rights. And why not? An interesting question. At one point in time, James Madison said we don't need one because the Constitution, it provides for a very limited government. And so it doesn't give the government power to do any of those sorts of infringements that we're concerned about. He himself knew that that was not a really solid answer. It is true that the states already had Bill of Rights. Madison also felt that it would just be a parchment barrier and that the real checks on government power have to be built into the structure of government. He even argued that it might be harmful to list a certain number of fundamental rights because that might suggest that there aren't others. And like a lawyer, he wanted to allow for the possibility that there might be more. And it's also been said, and it's probably the biggest reason of all, that the delegates to the Constitutional Convention were exhausted, having been through so many disagreements and compromises and so forth, and they just couldn't find their way to go through the Bill of Rights back in 1787. So it got deferred, although there was a lot of demand for it. And even as the ratification conventions were held, the views were expressed that we can approve this document, but we're going to need a Bill of Rights. And the document provided that once 9 states had ratified, this new United States would come into being. And that happened with the ratification of New Hampshire on July 21st, 1788. And in 1789, the new government commenced with 11 ratifications. Two states, former colonies, but at that time independent states, had not yet come in. Washington was sworn in Federal Hall of New York, and the new Congress convened in New York initially. It would later move to Philadelphia and, of course, eventually to Washington, D.C. And in that initial meeting, James Madison rose up to do what he had promised to do, and that is to introduce amendments which could constitute a Bill of Rights. And, we're used to the idea that the amendments are all listed at the end of the document, but that isn't the normal way that you alter and modify a document. In fact, Madison expected to simply put some additional clauses into the text. And he would have put them in Article 1, Section 9, which was the section that limited powers of the federal government. But the members of Congress had such an esteem for the document that they didn't want to alter it. They considered it a kind of a sacred pact between the people and the government. And they ended up adding the amendments on in the end as in the form that we're familiar. So Madison proposed 14 amendments, and 10 of them eventually became the Bill of Rights. Amendments 1 through 8 describe specific rights of the people, which are given special protection. Amendment 9 says that other rights are maintained by the people. And Amendment 10 says that all powers that are not given to the United States are reserved respectively to the people. By the way, number 9 does say the enumeration in the Constitution of certain rights shall not be construed to deny or disparage others retained by the people. So the list might not be complete. There might be more out there. And Amendment 9 has been relied upon to some degree in Supreme Court arguments, regarding rights that are not explicitly listed in the Bill of Rights. Okay, so this is a the states all had Bill of Rights. This was the Virginia Bill of Rights section on freedom of religion. It's worth looking at. It's from 1776. It says that religion or the duty we owe the Creator and the manner of discharging it can be directed only by reason and conviction, not by force or violence, and therefore all men are equally entitled to the free exercise of religion according to the dictates of conscience, and that it is the mutual duty of all to practice Christian forbearance, love, and charity towards each other. Okay, so you'll note that this has a much different tone to it than the First Amendment does. It actually starts out sort of assuming that everyone has a duty to the Creator, everyone has a duty to be religious, and in fact, everyone has a duty to practice Christian forbearance and Christian love. So what you don't see here is the concept that I'm mostly going to focus on this evening, and that is the concept of non-establishment, that not only would there be free exercise allowed, but also that the government itself would refrain from advocating a specific religion or even religion in general as it came to evolve. The amendment as Madison proposed it was that the civil rights of none shall be abridged on account of religious belief or worship, nor shall any national religion be established, nor shall the full and equal rights of conscience be in any manner or in any pretext infringed. You notice now we have the establishment concept coming in. There shall not be a national religion. We're far beyond, you could say, this kind of language from the Virginia Bill of Rights. As enacted, different proposals came out of the House and of the Senate. There was some kind of compromise committee, and as enacted by Congress and sent out for ratification, the first phrases of the First Amendment read, Congress shall make no law respecting an establishment of religion or prohibiting the free exercise thereof. So now, of course, no one, even the most strict constructionist, would say that this only applies to Congress. It is understood that this applies to the entire government. As at the time that it was enacted, it applied only to the federal government. I'll explain that a little bit more. So what is an establishment? From freedictionary.com, an established church is a church that a government officially recognizes as a national institution and to which it accords support. But we're going to see that the Supreme Court elaborated or enlarged this notion of establishment as to what was being prohibited by the First Amendment. I just want to note in passing that Madison felt that this same obligation to respect freedom of conscience and certain other freedoms should also be imposed on the states at the time that he proposed his amendments. But this failed to garner congressional approval and was never considered by the states. So the original Bill of Rights did not affect the states at all. In other words, a state could have an established religion. And in fact, multiple states did have established religions. For example, Connecticut, the official religion of Connecticut was the Congregational Church until 1818. For Georgia, it was the Church of England. For Massachusetts and New Hampshire, it was the Congregational Church. Interestingly enough, two states that people often think may have had official religions, Pennsylvania and Utah, at no time had established religions. Other states did. Eventually, when the 14th Amendment was enacted, the First Amendment came to apply to the states as well, and so there can no longer be an established religion in a U.S. state. However, there continued to be established religions in various nations of the world. The Universal Declaration of Human Rights advocates and supports free exercise of religion, but it does not, let's say, forbid the establishment of religion. And at this, the Catholic Church was the official religion of, for example, Austria and Brazil. They were disestablished in these years. Lutheran Church is still the established religion of Iceland. Church of England is still the established Church of England. Fascinating to learn a little bit about the history of established religions in various countries, although generally they have been disestablished. They're not official religions anymore. One major exception is in the Islamic world. For example, Saudi Arabia is an Islamic state. The Saudi Arabia has something called a basic law, which is analogous to a constitution. But that basic law of Saudi Arabia declares that the constitution of the Kingdom of Saudi Arabia is Almighty God's book, the Holy Quran, and the Sunnah traditions of the Prophet, peace be upon him. Okay, now you can imagine that it would be rather unwieldy to adopt the entire holy book and all the traditions as your constitution. But that is what, Saudi Arabia declares to do. Article 7 of the Basic Law provides that the government derives its power from the Holy Quran and the Prophet's Sunnah, which rule over this and all other state laws. And Article 8 provides that the government of Saudi Arabia exists in compliance with the revealed law of Islam. So Saudi Arabia and certain other Islamic states function in this manner. They adopt the Quran and the teachings of Islam as their constitution. Now then, they still have to make do. They still have to function as functioning states, and so they rely upon some more abbreviated and clear set of laws. But that's what it looks like, we could say. That's what it looks like to have an established religion based on a sacred text. Now, as I said, if the U.S. had stuck with that dictionary definition of established church, presumably the only thing that would be prohibited would be an official church. But the notion of establishment expanded ultimately to conform more with what Thomas Jefferson had in mind in the beginning, and which he put into his letter to the Danbury Baptist Association. This is a part of the opinion in the Everson case, which involved school prayer. This was written by Hugo Black, and you'll see he incorporates Jefferson's language, into a Supreme Court opinion. It's not in the Constitution, but it is in the opinions of the Supreme Court. The Establishment Clause meets at least this: neither a state nor the federal government can set up a church. Neither can pass laws which aid one religion, aid all religions, or prefer one religion to another. And I'll skip a little bit. In the words of Jefferson, the clause against establishment of religion by law was intended to erect a wall of separation between church and state. Now, having laid down this more broad principle, the court has always found itself facing difficult questions. and it's really been difficult for the court to articulate a doctrine or rule whereby it can decide these kinds of questions. There was a test called the Lemon test, which has now fallen by the wayside. I don't have to explain it to you, but I'll just put the questions out there. Can the state authorize a voluntary non-denominational prayer in a public school? Can the state provide tuition vouchers for use in schools, including religious schools? Can the 10 Commandments be displayed in a courthouse? Can a nativity scene be on the county courthouse lawn? Maybe you can answer those questions in your mind before I show you the answers. Does the establishment law permit this? Here are answers that the court arrived at. No, the state cannot authorize a voluntary non-denominational prayer. That's too close a connection between church and state. Can it provide tuition vouchers for use in schools, including religious schools? Yes. Can the 10 Commandments be displayed in a courthouse? Maybe. If they're part of a broader display which deals with, where law historically comes from. And there was a judge in the South recently, I think his name was Judge Moore, and he put into his courthouse a display of the 10 Commandments, and it said, the laws of nature's God. Now, I don't agree with that description. The Declaration of Independence uses the phrase laws of nature and nature's God in a very broad and comprehensive manner. So it wasn't intended to be limited to the God of the Bible. In any event, Judge Moore was required to remove the 10 Commandments from his courthouse. A nativity scene on the county courthouse, again, maybe so if it's part of a larger display involving the season. And yet, of course, the Supreme Court opens with a God save this honorable court. Congress opens with a prayer. These things have all been justified as having cultural and historical significance. So it's been very difficult for the court to articulate and consistently apply a clear rule as to what this separation between church and state means. Now, Larson v. Valente, by the way, the Jehovah's Witness Church brought many cases to the Supreme Court. I forgot which justice said, how much we owe to the Jehovah's Witnesses for this entire body of constitutional law that has developed as they challenged various acts under based on the First Amendment. It turns out that even though, Adams felt like, well, this parchment barrier is not going to be effective, Jefferson anticipated that there would be litigation and that courts would be used to uphold the rights. And that has become very much the tradition of America through judicial review. It's a very important tradition. This particular case, Larson v. Valente, was a unification church case that went up to the Supreme Court. It was decided in 1982. Minnesota's Charitable Solicitations Act provided that only those religious organizations that receive more than half of their total contributions from members or affiliated organizations are exempt from registering and reporting requirements of the act. So the act set up certain types of reporting requirements, and then it distinguished between a church that did a lot of public fundraising, like the Unification Church did in those days, and a church that basically relied on the tithes and contributions of its members. It's kind of like, this is good, this is not good. That went to the Supreme Court, and the court struck that down. And that was Justice Brennan. And he wrote that the clearest command of the Establishment Clause is that one religious denomination cannot be officially preferred over another. And he said that was what was happening in Minnesota, and the court did not tolerate it. Now, another case involving the Establishment Clause that has not made it to the Supreme Court, it could potentially. That is the what's commonly known as the UCI case. When the case was argued in 2022 in the DC Court of Appeals, the caption was Moon v. Family Federation, because Preston Moon and the other defendants had been found liable for misdirecting the assets of Unification Church International, or UCI, which was a holding company that the church created in order to hold valuable assets and in order to distribute funds to various causes that would advance the work of the church. And however, in this particular decision, the District of Columbia Court of Appeals, which is part of what you might think of as the state court system of the District of Columbia. The District of Columbia is not a state, but it is similar to a state. And this case was brought and litigated in that District of Columbia system. And this is the highest court in that system. And so in August 25th, 2022, the District of Columbia Court of Appeals invoked an Establishment Clause doctrine called the abstention doctrine. And that is that a court may not decide religious questions. Now, this is a very important doctrine, okay? This is a very important doctrine. This says that you can't come into a court to litigate, religious issues, matters of theology, or even the appropriateness of the organization of a church or something like that. So this abstention doctrine is an important doctrine to promote religious freedom, to assure that courts do not intrude into areas where secular courts shouldn't be passing judgment. The standard of proof in a court, in a criminal case, it's beyond a reasonable doubt. In a civil matter, it's preponderance of the evidence. We can't have a court be deciding theological issues based on preponderance of the evidence presented in a courtroom. So even though the plaintiff, which was Family Federation and certain other church-related organizations, had obtained a summary judgment against the defendants there, and some findings of fact were made that the defendants had abandoned their loyalty to the church and were using the funds for other purposes, ultimately they prevailed in the Court of Appeals, and the Court of Appeals wrote, "It is not for us to pass judgment on whose vision of the Unification Church or Unification movement is more faithful to the purposes UCI was established to advance. That religious question is outside of this court's purview." That is a very brief summary of that decision, and I realize you may be curious about that decision. You may want to talk more about it, but the essence of it was the court invoking the abstention doctrine. That case is still being litigated, by the way. Another case that involved the Unification Church, but wasn't obviously under the U.S. Constitution, is the Japanese Unification Church case, in which the Japanese government is proceeding to attempt to dissolve the formal church under a law that allows for the dissolution of a religious organization, quote, clearly found to harm public welfare substantially. And this, of course, unfolded in the aftermath of the assassination of the former Prime Minister Shinzo Abe by someone who had a grudge against the church. and who was not a member but had a grudge against the church. And this set off a kind of a chain reaction of hostility toward the church, ultimately leading toward this proceeding, which is still underway in Japan. I don't really have an update on it, but I can tell you that it was previously only invoked in cases where serious crimes were committed. But here it was being invoked based on claims of improper fundraising. For example, suggesting that donations would benefit the believer's eternal life. This kind of thing, this kind of claim has never been successful in U.S. courts. Again, the substension doctrine would mean that a court doesn't get involved in considering, the propriety of this question, let's say. Now, I just want to make a few other comments. I haven't talked about free exercise. The First Amendment has the Establishment Clause and the Free Exercise Clause. Okay, no establishment, and you must permit free exercise. Now, this, of course, is a vast and profound topic. A case back in 1879 that involved the anti-polygamy law effective on federal territories was challenged by the Mormon Church, and they said that free exercise of the Mormon religion at that time required, that a man be able to have more than one wife. And they selected a plaintiff, George Reynolds, kind of put his life on the line there, and challenged the law. He was kind of an attractive plaintiff. He was a younger man. He had 2 wives, and he said, "Free exercise allows me to do this." And the court essentially said, "You can believe what you want, but you have to obey the law." Now, I've never felt that that was a proper understanding of what free exercise means, because you cannot be punished in the Anglo-American system for your beliefs. There is no such thing as a thought crime. What we call hate crimes are actually enhanced penalties when a crime is committed against a protected group. But it is completely foreign to the Anglo-American legal system to punish thought. So the idea that we need an amendment to protect belief is not convincing to me at all. However, that rule, that old Reynolds rule, is still the court's interpretation of the First Amendment. It has not been altered. And I could tell you more about these cases, but I don't really have time to. I'll just say that the interesting thing about the free exercise and Establishment Clause, oftentimes when you are concerned about an establishment, you end up infringing free exercise. In other words, I'll give you some examples. Okay, I'll give you some examples from recent cases. Here's the high school football coach praying on the playing field case from 2022. Okay, he was forbidden from praying on the football field of a public school because that was considered too close connection between church and state. So in other words, it was considered an establishment violation. However, it was overturned on the basis that he had a right to free exercise of religion. That is the nature of establishment and free exercise. Even in the UCI case, when you tell the Unification Church that it can't be in court because the court has no jurisdiction, the church argued in part, but what about our free exercise right? You are curtailing our free exercise right by excluding us from court. This case here, another 2022 case, I told you that early on, and permit me for going backwards, but I'll finish soon. I told you that the Zellman case in 2002 said the state could provide vouchers for use in schools, including religious schools. Now we get to the Carson v. Macon case, in which the court said that prohibiting, limiting the vouchers or the tuition assistance to non-sectarian schools was in fact discriminating against the non-sectarian schools and was a violation of free exercise. So there are a number of cases being decided recently, not just recently, but including recently, that really have emphasized more the free exercise aspect of the constitutional First Amendment provisions. And so I'm going to conclude by saying that if the Supreme Court maintains its current trend of enhanced respect towards religion, and if the court itself can maintain its legitimacy, because there are challenges to the very legitimacy of the court in this time. But if it can do those two things, it appears that the First Amendment will continue to offer significant protection to religious liberty. And I will wrap it up there. I thank you for your kind attention.
Yeah, really a brilliant presentation, Professor Ward. I really learned a great deal and appreciate the clarity and well-organized and dynamic presentation. I know some questions are being lined up in the chat column. Maybe I'll take a minute just to come back to what might be not a professional legal opinion, but what I'd like to describe as kind of common sense, and it relates to this issue of, can I appeal to religious cultural rights as a way to avoid criminal prosecution? And you mentioned some of these, like the use of peyote, and there's the issues of some issues related to sexual issues like polygamy, or even in some cases incest, as being based on religious. But and there have been, I think, cases where there's been dissent within a given church, a denomination, let's say, where, and this can happen in a polarized political environment, where a church starts to divide prior to the mother church dividing. And then the question of who takes the property of the church, who's entitled to that property. But my question is, can you commit a crime and have a case, let's say, of theft, and justify that in the name of some cultural, in the same way that you would justify the use of peyote?
Well, by the way, the peyote case, that was a loser for the defendants. Just like it was a loser for George Reynolds. So the rule of the court today is that if it violates a criminal law, free exercise is not going to help you. Okay. However, one of the cases that I didn't spend time on, the Sherbert case, tried to give a more, let's say, nuanced approach, and it tried to say that if there's a substantial burden on religious belief, then you have to look at the state interest, and you have to see, is it a compelling state interest? And is there any other way to achieve that compelling state interest? So in the Reynolds case, the court actually wrote, if we start allowing things like polygamy, then someone's going to want to justify human sacrifice. That's actually in the opinion, okay? That's called the slippery slope argument. Or the, what do they call it? The parade of horrors argument. This more nuanced approach would allow you to deal with that. You would say, no, we're not going to allow human sacrifice. The state has a compelling interest in preserving life, and the only way to do it is through our homicide statutes, let's say. Now, you gave, another example would be, what about breaking the law, in the way that the civil rights demonstrators did, the way Martin Luther King did, and you say, I am following a higher law. Well, the current court interpretation does not allow that. Okay, the criminal law is supreme under the court's current doctrine. And I'll stop there before I make it more complicated.
Well, just a quick follow-up. We also get the individualization or personalization of religion. So, I can remember discussions here at HJI about religious holidays and when a person can legitimately not show up for work or maybe to class or something. And it's not only kind of the official religions, but there are legal protections for a personalized religion. Like I have a very individualized religious view. Is this leading to some kind of other kind of slippery slope where we move losing the integrity of the First Amendment? I don't know.
Well, it's interesting. Let me say that the Bill of Rights really concerns government conduct. And you know, there's a lot of legislation, civil rights legislation and other legislation that deals with the more private conduct. So those kind of contractual rights would actually fall more under the legislation rather than the Constitution itself. And you know, these are problems. These are problems that courts and others wrestle with.
It's really been a fantastic evening and brilliant presentation. As others have rightly indicated, we're delighted to have shared this evening with you, learned a lot and been enriched through it. Give you a final word, and then Dean Boyd, if you could come back in and close us out for the evening. So, Bill.
Well, I'll just say that it's my privilege to engage with this wonderful, thoughtful audience. You know, this family of HJI, which includes anyone who dropped in to listen. So it's my privilege. I love to talk about these things, and I appreciate the opportunity tonight. And I hope we can continue our dialogue.
Yeah, well, thank you, sir. Dean Boyd.
Well, thank you, Dr. Walsh. And again, Professor Lay, thank you so much. Your explanations about the different topics you've covered in our series here at HJI have always been so clear and easy to understand. So it really a testimony to you as a clear thinker and someone that has made a big difference, of course, in your law practice, but also in the affairs of our greater unification community. So thank you. Thank you for your service. Thank you all for coming. We have the Faculty Roundtable programs each month. So be on the lookout in your email inboxes for the invitation for our next program in the month of October, topic and date to be announced.